be able to provide you with what you need. But with that being said, happy Thursday. Happy Thursday. Hope everyone's doing well. Hope everyone's doing well. Um, I like the reminder that Mrs. Hermosi, confidence is an output. That's what she said, right? Confidence is an output, not an input. Um, it reminds me of, I'm just looking for our slide deck. It reminds me of, hey, Dean, I emailed you. It's almost closing time, right? It reminds me of a reminder that I would share with you guys regarding your attendance of trainings and learnings, right? Competence increases confidence, and confidence increases compensation. So it's always important that you guys take the time to learn because I find, I don't know about you, but I'm less likely to raise my hand to offer to do something or jump in if I'm not confident that I know what I'm talking about, right? So with that being said, I'm pretty sure we're all built the same way. I'm just moving some stuff around on my screen. You guys see me moving some stuff. You're not shy, Jerry? Um, Believe it or not, I'm shy. I think I am. I think I would absolutely consider myself shy for sure, if you can believe that. Um, and so I always say it, most people they're not willing to just jump out there and have conversations about things, but generally it's because you're just not confident maybe on the topic. So competence increases confidence, and confidence increases compensation. All right, here's our slide deck. Oh, that took a lot of maneuvering. Hey, Salma, good to see ya. That's true, right? All right, perfect. All right, our slides are up. We still got our folks coming in. Today's discussion, protect the escrow deposit. Protect the escrow deposit. So, of course, as a closing attorney, as a real estate litigation attorney, this issue comes up uh, more than it should, more than we would like for it to. One thing I always say, the most unexpected and most unfortunate outcome for any buyer is for them to either be at risk of losing their escrow deposit or lose it outright due to some default that potentially could have been avoided, right? I would say all could have been avoided, but sometimes you kind of get in a situation that something just the bottom fell out at the last minute. You did everything that you could do. But our discussion today is to make sure that you are poised to do everything that you can do to protect your buyer's escrow deposit, right? All right. So with that being said, I think I skipped very far. Oh, yeah, we were way far. Okay, there we are. We're not at the beginning. Quick introduction. A lot of familiar faces in the room, but a quick introduction for those who I have not had an opportunity to meet before. My name is Ray Cole Jackson. I'm a South Florida real estate attorney. A little bit about me personally. I am originally from Miami, attended the University of Florida for undergrad. So I always say go Gators. Flew out to California where I attended law school, came back home to Miami and got my LLM in real property development. I am a proud licensed Florida real estate sales professional. Got my first license in California during law school, and also a licensed Florida mortgage loan originator. And so for that, with that, I am ready to have a conversation about all things real estate, all things real estate. And with that, and based on that experience and that love for really just supporting not only consumers, buyers, sellers, but also realtors in their real estate investment endeavors, we've branded Purchase Ready. Purchase Ready is born out of, again, various, I guess I would say, scopes of my experience. One as an investor myself, right? You guys know that opportunities present themselves. And if you're purchase ready, right, knowing what it takes to make a real estate purchase, then you can take advantage of opportunities, right? And so purchase ready came out of that. It also came out of being ready to service a buyer or seller who's looking to make a real estate transaction. So purchase ready is an all-encompassing brand, is all-encompassing service, and is also an all-encompassing ecosystem, right? For not only consumers, but also realtors. For consumers, it is my idea because I don't know about you, but me, I like a one-stop shop. I like to go to Amazon and get everything I need. I like to go to Walmart if I'm going in person and get mostly everything that I need. And so that's where really society is pushing towards. Everybody likes to kind of get everything in one place. And certainly if a consumer has had a great experience with you in one facet of the transaction, then they're looking for the opportunity to continue to work with you as a trusted guide. So with that being said, Purchase Ready Academy is intentionally crafted and curated curriculum for real estate professionals who are looking to make their service offering a professional, streamlined experience. One thing I can tell you guys more and more as I work in this space, if you have a very effective relationship with title, with mortgage, it will 100% increase your business. It'll increase your business because it'll reduce stress. It'll increase your business because it will allow you to have your customers to have a great experience, right? It'll also increase your business because a good, for example, loan originator is going to tell you about how we talk about market the money, right? Giving you clues and insight concerning the financing arena that you can utilize to then go and educate your customers, right? And increase business. So that's the goal and vision of Purchase Ready. And so we've been developing that and seeing great success and just looking forward to the success that you guys as realtors get by virtue of participating in these courses. All right. So with that being said, protect the escrow deposit. What is an escrow deposit? So the first thing I want to make clear of, and I think many of you know this, but just in case, a little background legal knowledge. In Florida, an earnest money deposit is not legally required to make a real estate contract binding, meaning you do not have to make a monetary deposit if that's not what you've agreed to. There's a phrase in contract law we call a promise for a promise, right? Promise to sell. Sorry, handout is in the chat. I miss that every time. Promise for a promise. So outside of having negotiated to make an escrow, a monetary deposit, the parties could just agree promise for a promise. I promise to purchase if you promise to sell, right? But we know that in Florida, our established practice is to demonstrate the buyer's commitment to the purchase by making a monetary deposit with either an escrow company, title company, or a real estate brokerage, right? So that is an escrow deposit. So again, that's just a little background information for you. Now, why is the escrow deposit important? Because generally, it is the seller's liquidated damages in the event of a buyer's default. We know that there are other remedies that the seller can explore. However, generally, that's where they kind of stop at. Liquidated damages is the legal term where we essentially say we agree that this monetary number will be sufficient to cover me for all of my damages, right? Liquidated damages. That means, my exposure could potentially be $500,000, but we agree that in the event of a default, I would take $50,000 as liquidated damages, right? And so again, I just use that concept to point out that there are other remedies in the contract, right? The seller can sue for damages, meaning I've had my property off the market for 6 months, 9 months, 90 days, 120 days, or, I forewent other potential offers. I've been damaged. And if they can show actual damage, right, they can show that they lost money actually, then that's another remedy that they have. But again, in most cases, the escrow deposit is the extent of the seller's recovery. And so for that reason, when you're negotiating an offer, the sellers want to see as much of an escrow deposit as they can negotiate for, right? They want to see that the buyer has what we call some skin in the game. Now, with that being said, today, I've said this for 2 weeks now, I don't expect us to take much time today. I've said that for 2 weeks now. two main concepts we want to hit today. One, what are some of the most common areas of default that would place a buyer's escrow deposit at risk? And then secondly, in the event of a default, what are the seller's remedies? What is the course of action that you should understand? The contract has in it your course of action. And it's important that you understand this because if you understand this, I believe that it will cut down on some of the knee-jerk reactions to most often delays, right? Most times it's not really a outright default per se, or it's not a default as yet, but it has been a delay, right? So the delay is requesting an extension, and the seller's like, I'm done with them. Let's just get their escrow deposit. You guys are going to find out in the second half of our discussion today. Yes, that's a possibility, but it takes more than just making a demand for it, right? In order for you to access it. So with that being said, what are some of the most common reasons for a default? Missed deadlines. That's generally just it, right? The buyer they made an agreement to perform a particular task by a particular date, and they failed to do that. They failed to perform. So last week we talked about how to determine the contract effective date. We had a very long conversation about timeline, right? Number one, determining the contract effective date. And then once you are clear on the effective date, the procedure or the framework to count forward to identify your deadline, right? So as a recap from last week, that's kind of two-part, right? Two-part, meaning one, you as the realtor, you need to not make a mistake about what the buyer's deadline is. And then part two of that is the buyer cannot miss that deadline, right? And so we know that in counting, our determining our deadline, when we are counting that timeline, we must know what the effective date is. And then again, just a quick recap, we know that the effective date is the date when the fully executed contract is delivered to the other party. Now, we know that the contract language verbatim says that when it's signed and delivered, but most times, just to make it simple, because you're the most important piece of that two-part sign and delivery is delivery. Remember, we talked last week, if I sign today, but I don't deliver for 3 days, the effective date is 3 days from now, not the date that I signed, right? So that's just a reminder on that. So now knowing what your effective date is, how to count forward to your deadline, some of the most common deadlines that are missed. The first one is failure to make an escrow deposit. That's not super common as it was in the past, but that is a default, right? And so what is the seller's remedy in the event of a failure to make an escrow deposit? 9 times out of 10, just move along, right? They cancel the contract and move along to another buyer. I've had people ask questions, well, can we go after their escrow deposit because they failed to make an escrow deposit? I mean, you can, but does that really make sense, right? Because now you have to like, can we force them to make the deposit so we can keep it? That's just not even worth your time. It's just not even worth it because that's a lawsuit, right? That's a for damages. And then as we're going to talk about later on, there's even a step before you get to the lawsuit. So for that reason, it just doesn't make sense. Now, in the event of a transaction where they've made 2 deposits, right? You have a first and a second, or maybe even a first, second, and a third. Now we're having a different conversation because there at least is some money in an escrow account somewhere to have a conversation about. But if the buyer has just not made an escrow deposit, they've blown that escrow deposit deadline, it's best for you to just cancel the contract and move along, right? All right. And so here we just get an example screenshot of where you are notating when that deposit is to be made, right? So first deposit, second deposit. I want to do a quick another recap because last week we did a hypothetical and this question was missed. And since we have the language on the screen, we may as well review it. In our hypothetical last week, that contract had a first and second escrow deposit. And when we were going over the hypothetical and we did the quick quiz, learning quiz, some colleagues made that second escrow deposit. they count it from the date that the first escrow deposit was made. And that's not the measure. As you see here in line 36 of paragraph B, if there's a second escrow deposit, it's within 10 days after the effective date, not within 10 days from when the last escrow deposit was made, right? Just wanted to make that point. Since we have the language on the screen, we may as well use it. I don't think last week we didn't have the language on the screen. So since we have it on the screen, this is where that came from. If you guys remember last week, some counted from the date that the escrow deposit was made. The contract, the template language does not say that. The template language says from the effective date of the contract. Now, of course, like I told you guys last week, you can always strike through and put, 10 days after first escrow deposit made, but the template language says from the effective date. All right. All right. The second most common case of default is, of course, failure to comply with the terms of the financing clause. And what does that mean? One of the first terms, make an application for a loan. You guys should not have this issue. Any buyer that you work with should already be pre-approved. And that's all I'm going to say about that. So you should not have a default for the buyer failure to make an application as provided in 8B1, because your buyer should have already made an application because they're pre-approved, so that they can be pre-approved, right? Now, what is most commonly not adhered to, a deadline that's adhered to, is the loan approval deadline, right? And we should really call that conditional loan approval. We used to have, what do we used to call it? Commitment letter, I think. Contingency, I forget what they call it. Just that quickly, I forget what we used to call it. Loan commitment, I think. Now we call it loan approval. We actually changed the language. But I just want to make one caveat there from a practice point. Although we call it loan approval, you guys know that by this deadline, generally the buyer has a conditional loan approval. They don't have a full loan approval, right? Loan approval comes when they've met all the lender's requirements, right? And the reason why I make that point is because even though the language in the contract says loan approval, this loan is not fully approved until it's fully approved, right? Until you get it clear to close. And so I just want to reiterate, because we've talked about this a couple times before, your buyer generally at this time point, they're going to have a conditional loan approval that they'll still have conditions to comply with in order to get a clear to close. Notwithstanding, the lender has issued a conditional loan approval. Once you get past this deadline, the buyer cannot cancel the contract due to loan approval and just outright expect to get their escrow deposit back. Is that clear? Just because the lender's letter says conditional, meaning that there are still conditions that need to be met with them, that does not continue this contingency period. That does not extend the contingency period until the lender approves it. So for that reason, in working with your lender, you want to be sure that they understand, okay, great, I see we got a conditional loan approval. Are we good? Like, do you expect us to not have any issues with these conditions between now and closing? Because this is my deadline to cancel this contract, or the buyer's deadline to either extend the loan approval period or cancel the contract if you're not confident that we're going to ultimately get a clear close. All right. Simon's question, do we have to select the financing type? Yes, because if you don't, you're not tying down your buyer's contingency, right? So for example, last week we had the question about the buyer making an offer, and in their offer, they marked that they were going to proceed with a conventional loan. When in reality, not sure if they always knew that they were going to need FHA and they just made the offer conventional. But in reality, they needed to pivot to FHA. Now, we know that FHA has a rider that has additional conditions in it. Well, now you cannot bind the seller to FHA terms because you didn't select it. So the question, can they select both? Absolutely. You can select all three and other, right? Because what you're doing when you complete this section of the contract, you are tying down what terms your buyer needs to be offered to them in order for them to proceed with the transaction, for this to be contingent. Now, understand that the seller has to be okay with this, right? So let's say, for example, you make an offer, you check off conventional, FHA, and VA, and they're like, wait a minute, wait, I don't know about them, but I would be like, wait a minute, which way are you going? Because that's three different underwriting guidelines. Are you pre-approved or not? Right? Because if you're pre-approved with a loan product, right? Question in the chat, should we give the lender more than 30 days? It depends. I would say to you, if I were a listing agent, I would be concerned about giving more than 30 days. Here's why. In today's origination environment, a buyer, depending upon the lender that they're working with, they can be fully pre-approved as it relates to them as the borrower. Quick detour to help explain this, what I'm describing here. Remember, we talked about before that for a full loan approval, the lender is looking at, we look at the acronym IPAC, IPAC, Income, Property, Assets, Credit. In order for the lender to give a full pre-approval, they've confirmed that the borrower's income, that the borrower's assets, and that the borrower's credit are sufficient, and then that the property is sufficient. How do we confirm the property? Appraisal and title search and survey. So my point to say to you that 30 days, I would question that, is because a lender can, prior to a buyer going under contract, fully vet them for income, assets, and credit. That can be fully vetted, right? If they're working with a lender that allows for this. And when I say allows for this, meaning that they have the manpower to dedicate to fully, we call it an underwriter's pre-approval, so that the underwriter pre-approves them, so that when they go under contract, this is why you can make an offer and say, well, I can close in 2 weeks. Because I'm already approved. It's now the lender needs to approve the property. And we can get a property, we can get an appraisal, title search, lien search, survey, and estoppel if it's in that type of community in 2 weeks, right? Is that clear? What about 92? Do most agents leave this blank or fill it in what they feel comfortable with? They fill it in what they feel comfortable with. Again, you can, but with that, I wouldn't leave it blank, because you see what the default language is? If left blank, then prevailing rate based upon buyer's credit worthiness. That's prevailing rate. We all know what prevailing rate looks like right now, right? So buyers like, I can approve you, but you're gonna get a rate of 8%. I don't want that, right? Well, if you don't put anything here, then you left yourself open. You've had a lender tell you to leave it blank. I wouldn't leave it blank. I would not leave it blank. I wouldn't leave it blank, because again, you got to look at the contract. If left blank, then the prevailing rate based upon buyer's credit worthiness. Here's the deal. You can always go above, right? So we know that 2% interest rates, good luck. They're a dinosaur. You're not going to see it again. I can put 2% in here, knowing that I'm likely going to get 5.99, 6%. So I can always go above. I, as a buyer, can go above, but I can also say, oh, I told you I need to get 2%. So I'm backing out. So again, with that being said, the listing agent is going to look at that as well and say, 2%, when? We haven't seen 2% since COVID, right? So why would you? No, I'm not accepting this offer. Everything else in this offer can look amazing, except let's be realistic about what the potential interest rate is going to be. All right. All right. All right. So written notice of loan approval status delivered to the seller by loan approval deadline. So we know that by the loan approval deadline, the contract provides that the buyer will provide written notice to the seller of their loan approval status. And we know that can either be they've received it, and so they'll maybe share the conditional loan approval or just send a quick email from the loan officer. The second is loan approval not received, but proceeding with the transaction, right? The third is, I'm not gonna be able to get it, right? Like we've added 3 buyers and 4 more to the loan and I still can't get it done. So I need to cancel the contract and get my escrow deposit back. Now, I will tell you in this particular case, failure to provide written notice is not a default to the extent that the seller to where their escrow deposit is at risk by itself. But here are some potential non-favorable outcomes. One, we know that, let me see here, let's go back here. We know that if by chance the seller was just waiting for the loan approval period to come because they wanted to get out of the contract. Remember I told you guys that's always theirs, right here in paragraph 8B5. The seller can terminate the contract. Seller may elect to terminate this contract by delivering written notice of termination to buyer within 3 days after expiration of the loan approval period, right? If the buyer fails to provide, let's just go ahead and read from the beginning. If buyer fails to timely deliver written notice provided for an 8B3 or 4 above to the seller prior to expiration of the loan approval period, then buyer shall proceed forward with this contract as though paragraph 8A above had been checked as of the effective date. That means you are not going to be able to move forward and then cancel this contract because you didn't get financing. 8A is cash, right? So failure to provide written will A, cause you to move forward as if it's a cash transaction, meaning you can't rely. Or it says here, provided, however, seller may elect to terminate the contract by delivering written notice of termination to the buyer within 3 days after expiration of the loan approval period, right? So failure to provide written notice has 2 potential non-favorable outcomes. One, if you don't get approved, ultimately, you're in trouble, right? Your escrow deposit is at risk. Or let's say you are actually fine, but you just did not provide the seller notice. But yet your seller was itching to get out of this contract. You didn't provide the notice, they provide you the notice that they're terminating. All right? So now you guys know that that's there. All right. Failure to cancel the contract during the inspection period, not necessarily a default, but for example, if it's a cash transaction and you have no other contingency, no other basis for canceling, now you're stuck, right? Now you're stuck in the transaction, and should you need to cancel for some reason, that escrow deposit is at risk, right? Quick questions. If we fill in line 92 conventional FHA, can they change at closing as rate may be floating? Yeah, they can change the rate. Again, this is, look at the finance contingency as your buyer's protection, right? Such like, for example, looking at the loan type, I put in FHA, but I could switch to conventional, which remember, conventional has lesser underwriting requirements than FHA. So the point is you want to put yourself in the most, if you can, you want to structure it in the most protected manner, but then the buyer can always deviate from that and close. You can't deviate from that, however, and then create additional tasks or responsibilities or obligations to the seller. Can't do that, right? So for example, you can't make an offer that you're conventional, then try to change the FHA, and FHA requires heightened inspection, heightened property conditions, heightened appraisal requirements. Like, wait a minute, I never told you I was going to do all of this, right? We went under contract for conventional, so look at it that way. If you have the buyer and they don't have the loan approval by deadline, is there a form to provide the seller to notify that they don't? Well, they need to cancel. Well, it depends. So let me go back. I don't think I have it in this slide where we say you represent the buyer. This is a good question. Seeing how all this stuff weaves together. We talk about this more in the other classes, what happens in this case, but let's talk about it now. You have the buyer, you're at the loan approval deadline. The buyer does not have the conditional loan approval. What do? One, first of all, you're either going to seek an extension of the loan approval period, right? And if you extend the loan approval period, then you probably should just go ahead and extend if you can, get the seller to agree to extending the closing date, because generally, if the lender needs more time to clear the loan to get them up to conditional approval, then they're probably going to need more time to get them up to a clear to close. So at the very least, you want to extend the loan approval period. And if you can, you want to extend both the loan approval period and the closing date, right? Now, what if they say, no, I don't agree? Well, release and cancellation is the form that you use. Release and cancellation. If the seller agrees, then obviously you're just using an addendum. The loan approval period is being extended to, boom. Closing date is being extended to, and then that's that. If they don't agree, release and cancellation. Maria's question: if the loan is not approved within a time frame, the buyer can ask for an extension or cancel. Correct, Maria. If they are not approved within the time frame, best course of action is to extend the loan approval period and the closing date. That's the best course of action. Worst case is not say anything, because now you're in trouble, right? You cannot cancel and just outright expect to get your escrow deposit back. Moderate case is you have to release and cancel. All right. And this is just showing you paragraph 12 where your inspection deadline is. Failure to close on time. Now this is where it gets thick. Failure to close on time. All right. And the failure to close could be using, like we just talked about, maybe that conditional loan approval came through and nobody really kind of examined it, maybe. I don't know. Or maybe the conditional loan approval was very much, meeting those conditions were very much attainable, but your buyer drug their feet. This happens all the time. I'm gonna be honest with you, this happens more often than the opposite, where the conditions are clear. We need a W-2 from that job. We need tax or bank statements from that account. Like, it could be the easiest conditions, but the buyers, they're busy, right? Sometimes for some of these buyers, this loan application thing is like a full-time job, or at least a part-time job, right? And so, but time is of the essence. Time is of the essence. Like, if you represent a buyer, the best thing you can do, especially in your initial consultation, one of the best things you can do is, if they're financing, you get with that loan officer and you determine how much that buyer can be pre-underwritten before you go into contract. Even while you're shopping, how much further in the pre-approval process can we go so that we're not racing the clock once we go into contract? If you got a good loan officer, they'll tell you. Well, this is what we need, right? That's one of the best things you can do. Secondly, assuming you've had that conversation. Secondly, you want to have a conversation with the buyer and say, hey, listen, time is of the essence, and every request that is made of you, whether it's from the lender, whether it's from insurance, homeowners insurance, whether it's from title company, whomever, this will likely feel like a part-time job for you, right? Tell them, right, Dean? Yeah, this may likely feel like a part-time job for you. And guys, I'm gonna be honest with you, like mea culpa. As a loan officer, you can't write your own deals. You have to use a loan officer for most lenders. Most lenders, you can't write your own deals. And so, yeah, I've been like I was telling one of your colleagues, I've been both the recipient and the provider of delay because it's just like you like send bank statements. You send a bank statement with, and I use this joke with her on her deal. Um, you send bank statements and they review and they're like, what is this $50 Burger King purchase? What? Like, I need the receipt from the Burger King purchase. That's a pretty substantial Burger King purchase, right? And so it's just kind of sometimes never ending. And so if you give your buyers, set their expectations up front, but let them know like this is a 60-day period, 60 days of pain for a lifetime of benefit in this property that you're investing in, then, you kind of just set expectations, right? All right. So with that being said, I went off on a tangent on that, but that's what I see it so often. Closing date. What generally happens? Get up on a closing date. Like I said, lender's not ready. Lender's not ready. Buyer has not given everything that they need, or lender has not been diligent in getting what they need. But whatever the case, we're here now, and we need to extend the closing date. And let's say hypothetically, because this is about 70-80% of the time, seller is like dug in, like, excuse me? Like, they may give you one extension, but if you have to keep extending, and this happens, now they're flabbergasted. Like, no, we're not extending, and we're keeping the escrow deposit. How many times has that happened? Many times, right? So let's say we get to a point where you cannot talk your seller down. They're saying, no, we are not extending. I want the escrow deposit. So let's turn the table. Remember, we talked about setting the expectations of the buyer. Let's set the expectations of the seller. Buyer is impacted by this as well, but they're more so protected than not. Just because you determine that you want to cancel and you want the escrow deposit, unless that buyer agrees and they countersign that release of cancellation, there's a process to access that escrow deposit. You can't just send in an email, hey, Ray Cole closing team, they defaulted. Clearly, today is the 31st. They were supposed to close yesterday. Send me that escrow deposit. Here's my wire instructions. Like, it doesn't work that way. It doesn't work that way. How are they resolved? One of the first things that everybody should understand, and realtors included, the first line of resolution, if the file is with a non-broker, and even if it was a broker, there's mediation. There's either a mediation or there's a meeting of the minds. If the escrow deposit is with the broker, then you're going to FREC. But the point is, it's just not going to be, the escrow deposit is not going to be released right away. It's not going to be released right away, right? So here, before we flip the slide, I want you to see here. Remember I told you guys that C15B, that the seller, if you look at line 340, I'm sorry, buyer default. If buyer fails, neglects, or refuses to perform buyer's obligation under this contract, including payment of deposit within the time specified, seller may elect to recover and retain for the account of seller as agreed upon liquidated damages, consideration for execution of this contract, and in full settlement of any claims, whereupon buyer and seller shall be relieved from all further obligations under this contract, or seller at seller's option may, pursuant to paragraph 16, proceed in equity to enforce seller's rights under this contract. The portion of the deposit, if any, and this is what has been, I kept this in so you guys can see, this is a change in the contract. Remember, the contract used to say, the portion of the deposit, if any, paid to the listing broker upon default by buyer shall be split equally between listing and cooperating broker. That's gone. So just know that. If the seller retains the escrow deposit and they provide any portion of it to their agent, the buyer's agent no longer is entitled to a portion of that. It's been in there for a very long time. It is now gone, right? All right. So Who's the escrow agent? Remember, if the escrow agent is a broker, then we're looking at FREC. We're looking at the FREC rules to resolve an escrow dispute. If the escrow agent is a non-broker escrow agent, so for example, law firm, title company, then we're filing an interpleader action with the court. An interpleader action with the court means we go to the court, hey, here you go, these folks, here's the contract, here's the complaint. The buyer and seller over here, they have a dispute as to who's entitled to this escrow deposit. Here's the money. Here's their contact information. Can you work with them to find out who's entitled? You need to make the determination who's entitled to this escrow deposit. So with a non-attorney, those funds, if it cannot be resolved, it's going to be placed with the court. Now, the thing to understand is if it has to get to that point, the attorney, the interpleader, whoever has to file it, they're going to be entitled to costs, time to prepare the pleading, and the cost of filing an interpleader action. So for that reason, I'm piling on for you guys reasons for you to have a conversation with a seller to say, hey, listen, the time it's going to take to have this conversation, let's give them 5 days. 5 days. 5 days they're asking for to get it clear to close, get the CD out, and close. It's not worth it, right? Most times it's not worth it. We talked about FREC. Escrow dispute resolution. Can a title? No. So the question in the chat is, can title release the escrow deposit to the buyer after a certain amount of time? Absolutely not.
I mean, it's a title company.
No one. The escrow agent cannot. You cannot, without a countersign, fully executed, release and cancellation.
Excuse me. Is this always been like that, or?
Always.
Oh, wow. Because I've had a situation similar where after a while, like a few years, then the title company released the deposit back to the buyer. This was like a few years ago that happened. But this money was held in escrow for a long time, and then they finally released it back to the buyer.
I'm going to tell you what they probably did was they felt like no one was going to come back and ask about it, meaning the seller side. But the title agent's requirement is to hold funds in escrow. They are neutral, and they hold funds in escrow unless they have an agreed upon direction provided to them to release those funds. Escrow agent should never. Now, we're not going to go too far into this today because it's a little sophisticated, and I do this when I represent my sellers. You can place language in the contract that the buyer will agree to release the funds, the escrow deposit, automatically to the seller upon some condition. So, for example, I'll use a very basic example. Let's say, for example, buyer needs an extension. The seller has extended already, let's say twice, or maybe even this is their first extension. But they're just so gung-ho about not extending that they will agree to extend if the buyer agrees that the title agent, the escrow agent, is directed to release the escrow deposit to the seller, whatever date, without further direction or agreement from the buyer, in the event the transaction does not close by whatever date. That language can be placed in the contract. And again, it's a little sophisticated. If you try to do it, you can do it, but I would suggest you speak with an attorney about what that language should look like. But you can add that language to the contract, and that will avoid the escrow dispute resolution that is in the contract. The framework that's there now, it will avoid that. Do the monies go to the state of party candidate? Hey, Andre, no, it does not. They will reach a resolution. So, for example, we're here now. Mediation. Mediation is generally the first line of resolution, right? So we know that mediation is when the parties, the buyer, the seller, you go before a third party neutral. That third party will hear the buyer's side, they hear the seller's side, and they will make a recommendation. When you go to mediation, that third party neutral makes a recommendation of how the parties should resolve their dispute. I heard your side, I heard your side. This is what I suggest that you do to resolve this action, right? Now, the parties don't have to agree. You know, you can have a very, staunch seller or buyer, and they're like, no, I don't. I know the contract said I was going to close by the 29th, and it's now, you know, 2 months later, but I didn't default. They should have given me time, right? And the media are like, you're unreasonable, like, no, right? So if they don't agree to the mediator, then their next step is litigation. Their next step is litigation, unless, here's another caveat, unless you use the arbitration rider. So many different nuances, right? Unless you guys, when you went on the contract initially, you used the arbitration rider to agree that in the event that there's no resolution of a dispute at mediation, then you guys will go to an arbitrator. Now, the difference between mediation and arbitration is the same setup. There's a third party neutral. Each side tells their side of the story. But the difference is when that third party neutral is going to make a decision, just like a judge, right? Versus with a mediator where they make a recommendation that the parties can decide to agree with it or not. If you go to arbitration, that third party makes an actual decision. And so for that reason, there's always going to be a resolution. Who pays for the mediation? Both parties. Both parties. And if we just talked about arbitration litigation. If you go to litigation, the prevailing party is entitled to attorney's fees. The prevailing party is entitled to attorney's fees. So the parties will split equally any mediation fee incurred in any mediation permitted by this contract, right? That's your question, Andre. And each party will pay their own costs, expenses, and fees, including attorney's fees incurred in conducting the mediation. In any litigation permitted by this contract, the prevailing party, that means whoever wins, if you go to litigation, shall be entitled to recover from the non-prevailing party costs and fees, including reasonable attorney's fees, in conducting the litigation. If we go to litigation and I win, you pay me. I get to recover my costs, right? If a buyer got loan approval and in the month of waiting for closing lost their job, does she need to reapply? Yes, absolutely. They're not going to get their loan approved. They're not going to get a clear close. Now, if she loses her job, for example, the buyer can lose a job. I've had a buyer lose a job before and then get a new job. And then, you have a letter of explanation. Let's say, for example, they're in the same field, that will allow them to continue with that loan. However, if it's a situation where they've lost their job, they've not found another job, and or the lender's not able to get them approved, they're in default. I've literally had folks lose their job. Not my transaction. Well, been a file that we were closing, and a person lost their job. Lost their job right before closing. After the loan approval period, but right before closing. And I know you would possibly say, like, oh, the seller should, and the seller, I can't remember what happened in that particular case. The seller has the right to either be compassionate and release their escrow deposit, or say, I'm sorry, I kept this property off the market for X number of days. I would like to retain the escrow deposit. And the seller would be well within their rights. Yeah, because that's outside of their control. The seller's control. All right. All right. So key takeaways. Number one, monitor deadlines. Monitor deadlines. Document action to take to address a deadline. Right. So meaning if you get an extension, if they've agreed to extend the loan approval and closing date, let's get an addendum. Right. Seek resolution of disputes before legal action. We've talked about how exhaustive that process is, right? You got to go to mediation first and then arbitration or litigation. That can take easily 60, 90 days. Easily. And then oftentimes it takes longer than that, right? I literally still have escrow deposits in my account to someone's question, right? So the point for you guys as real estate professionals and as drivers of these transactions. Again, number one, know how to determine your deadline. Be sure to monitor those deadlines. In the event your buyer may not be able to meet a deadline, document it accordingly by either extending, or if it's a situation where you need to cancel, just cancel. And then lastly, if you get into a situation, again, this generally happens around closing, just be mindful of what I explained to you guys about how an escrow dispute is resolved. And so most times it just makes more sense to work through, if you can, right? If it takes more time, to just work through giving more time with conditions. Give more time with conditions, right? I had an agent text me and I said, extend with the kickout clause, right? Put it back on the market, back up off of with the kickout clause, meaning, all right, I'm putting this back out here. If someone comes with an offer, then you can get kicked out, right? Or backup offer. So there's a lot of ways for you to create conditions around an extension. You don't have to just do an outright extension and just sit and wait. We could probably do a class on that. But just seek resolution, right? How to continue to come to the closing table. All right. All right, Jerry, if the buyer loses a job after loan approval and after approval date, absolutely. Yes, it is at risk. Yes. Yes. What I want to be clear on is once you get past that loan approval deadline, there's no other contingencies. There's nothing with extending up. That's an option. I mean, we could literally, that's a good class. We should put that on the schedule. Just talk about all the different ways you can extend a deal, but put contingencies in there to protect your seller so there's not just extending without any benefit to them. All right. All right. Guys, next week, next Thursday, we will not be here next Thursday, but on next Wednesday, if you're a member of RAPB, there's a 3-hour 3CE contract class scheduled for Wednesday that I will be teaching. So instead of next Thursday, I'll be teaching on Wednesday, contract class. This class, today's training will be posted on YouTube by tomorrow. Follow us on YouTube. The link is in the chat to access it there. If this is your first time joining us and you found value in our discussion, we'd appreciate a 5-star Google review as we build how to register for the contract on Our World. Let's drop that in the chat, Jerry. I think it's www.ourworld. Go to Our World. Thank you, Ellen. ourworld.com. I think that's the link. If you're a member of RAPB, go to ourworld.com, go to education, sign up for the contract class. I'll be teaching that next Wednesday. All right. So reminder, we won't be together next Thursday. We will be together along with many others next Wednesday. All right. All right. It's on the dashboard. Perfect. All right. Summer, I see your question. Minnie, let's pause the recording. Let's answer some questions and we're gonna get out of here. Go ahead, Minnie. I'm sorry, Summer.
That's okay. You can call me Minnie. So if you're in a situation where the buyer defaults, the seller has hired movers, they've put a deposit down another property, they've now lost that deposit, they've incurred more cost than what's in the escrow currently, can they seek additional damages?
So hold on one second. Minnie, go ahead and stop the recording, please.